If we talk about Supreme Court registry, the system, how it works, it's very well systemized, computerized. But talking about laws delay, and if we effectively want to do something for it, nothing can be done unless and until the lower courts, the tehsils, the lower courts from where the cases come ultimately to the Supreme Court, they are computerized, and there the things work as in effective manner as they are working in the Supreme Court. There's no denying, if we talk about need for the speedy justice, there is no denying the fact that there has been a considerable increase in the crime rate in the entire country. Though the judiciary may not have the direct concern with the increase of the crime rate, it has a concern with the disposal of criminal justice and how delay in that area contributes to the increase in crime rate. The delay in disposal of criminal cases at the trial stage is not only against the mandate of law, but it also does a great injustice both to the victim and the society, as also to the assailant. It is injustice to the victim and to the society because human memory is short, and with passage of time, much evidence is lost, as apparently many influences are at work. The Supreme Court has time and again emphasized the need to speed up criminal justice delivery system in the country, though several loopholes which contributed to delay have been plugged by the Code of Criminal Procedure 1973, which find that there are several areas, but we find that there are several areas where the problem has not been adequately tackled. Delays are caused having regards entirely to the nature of procedural laws, practice and procedure followed by the criminal code and the inadequacies of the investigating and prosecuting agencies. Hearing by division bench and single judges. Under the rules of several high courts, criminal appeals are required to be heard by the bench of two judges. We are the entire agreement with the recommendation of the Satish Chandra Committee that the criminal appeals involving sentence of death or imprisonment of life should be heard by a bench of two judges. Further, the appeals against acquittal in cases which are likely to result in imposition of sentence of death or imprisonment for life should also be heard by a bench of two judges. All other criminal appeals and revision applications should be heard by a single judge. The relevant rules or statutory provisions in different high courts which do not contain such provisions should be suitably amended. Another aspect is anticipatory bail. Section 438 of the Code of Criminal Procedure confirms the jurisdiction on granting an anticipatory bail to the High Court as also the Court of Session. As Court of Session has the power to deal with Sessions case resulting in the imposition of death sentence or imprisonment for life, there is no reason why a court could not be considered advocate to deal with applications for grant of anticipatory bail. Needless time of the High Court would be spent in dealing with applications for grant of anticipatory bail. Therefore, it is recommended that Section 438 of the Code of Criminal Procedure be suitably amended, restricting the power of granting anticipatory bail to the Court of Sessions. Acquittals and appeals. We find that a large number of appeals are filed by the state, orders, judgments, acquittals, without proper scrutiny on behalf of the state. Therefore, it is recommended that the state government should set up proper machinery to carefully and objectively scrutinize the proposals for preparing appeals against orders, judgments, and acquittals before taking a decision to prefer appeals. Appointment of public prosecutors. The functioning of the criminal courts is often handicapped by the want of adequate number of public prosecutors. The state government should appoint not less than 2 additional public prosecutors for criminal court. Adequate attention must be paid to appoint competent lawyers as public prosecutors to improve the quality of assistance to the criminal courts. Service of summons. Trial of criminal cases is often delayed because the service of summons on the accused is not effected promptly. Similarly, delay occurs in securing attendance of the prosecution witness and even in securing the presence of the accused who are in the jail. The reason often assigned is that there are not adequate number of policemen and that the limited force available is required for emergency work, etc. The criminal courts do not have any effective control in this behalf over the functioning of the police constables. Therefore, it is recommended that adequate numbers of police constables should be attached to each police station exclusively to attend work of each court as per its directions. It is often noticed that delay occurs in serving medical officers, expert witnesses, and even investigating officers when they are transferred to other places and their new addresses are not easily available. To avoid delay in these circumstances, it is recommended that appropriate provisions should be made to serve these officers through their heads of the departments. Before I conclude, there are a few facts which I asserted above. A fact that hit one between the eyes is the pendency of cases in the high courts and more in the lower court, estimated at around 3 crores. A guess time placed the time required for the disposal of this massive tendency is at 150 years. Before I leave the dais, I am very thankful to the organizers of this conference for giving me an opportunity to share this dais with so senior lawyers and Mr. Honorable Justice Mr. Chatterjee. Till now, I've just appeared before him for taking few passovers, few adjournments, and today sharing a dais with him is a dream come true for me. And granted. You granted. On personal front, I feel that those such seminars are very essential, but what I feel is that such seminars should also be organized at the grassroots levels, the tehsils levels and district levels. Because until and unless we devise a program to make them and us come on a common platform to share our views on such topics, the system and taking their views also, we cannot form an effective judicial system for this discourse. Thank you.
Before I request Ms. Jagriti to speak, I will just remind Mr. Abbas, when he started practicing here, he said for the last 8 months. Last June I visited China. I was invited by a judge of the Supreme Court to see the Supreme Court. I went with my family, and believe me, I didn't see the judge in the court, I didn't see a client in the court, I didn't see an officer in the court. Nobody in the court. Whereas, look at us, we are taking up cancellation of bail matter, interim order not granted, coming to Supreme Court, then adjournment not granted or adjournment granted, these people are coming to Supreme Court. So this is how we are acting now. So may I request Ms. Jackie to speak.
Honorable Justice Mr. Arun Chatterjee, learned advocates and senior Indians. It is said by one renowned jurist that truth is mother of justice, justice is heart of law, and law is the pulse of nation. It is dream of Pandit Jawaharlal Nehru that justice in India should be cheap, simple and speedy. To translate the dream of Pandit Nehru in reality, delay in law and delay in justice should be avoided. Let us focus about meaning and concept. To understand the meaning and concept of law's delay, the best example is the famous case Husainara Khatun versus State of Bihar. Whenever we see any deceased person who has just got the date in his case, we can very well understand what is the law's delay and what is the delay in justice. Reasons for delay can be any: lengthy procedures, rising expectations of the people from the judiciary, public awareness, less number of judges, etc. etc. But what is the reality today? Today the reality is that 14,000 cases are pending in the Supreme Court, 37,000 cases are pending in the different high courts, and 25 lakh cases are pending in the lower courts. If any cases cannot be added, then also 124 years required to clear the backlog. This is the now reality. India has the lowest number of judges among the major democracies. India has judges 13.05 judges per million people against Australia. Australia have 58 per million, Canada have 75 per million, and UK have 100 per million, and US it has 130 per million. Clearly, in some high courts, cases filed now will not come up for hearing before 2010. Civil suits may have to wait for a decade more. Invoking the law seems to mean only wasted years, heavy financial burden, and emotional and physical trauma. The right of fair and speedy trial means nothing to over 3 lakh untrials machines in various jails whose upkeep alone costs the acquisition about 501 crore annually. Today, one people can file an application for the compensation of rupees 5,000, and he gained the justice when he lost his 5 lakh rupees. So that people are saying that justice delayed is justice denied. Reality is such like that whatever be the problems and shortcomings, the judiciary as an institution cannot afford to relieve the expectation of the people. What can the judiciary do? The steps for resolution can be divided into 3 bits. First, long-term planning. Second, the short-term planning. And third, certain self-determination based on introspection, which for implementation do not depend on any agency external to the judiciary. I would like to enumerate the steps which need to be taken. The first step, the number of judges has to be suitably increased. In one of its judgments, Supreme Court has expected the central and the state government to secure at least 5 to 6 times increase in the number of judges. Second step, judges need to be trained to face new challenges, continuing education, refresher courses and orientation programs. The potential information technology must be increased, utilized, administrating the justice system of the country. The court records needs to be digitalized. Email filing is the best example. And now the example is the www.saferindia.com website initiated by Ms. Kiran Bedi, video conferring, and similarly the methodologies can save lot of time and energy of those associated with the justice delivery system and can also avoid unnecessary movement of persons and papers from place to place. With the advent of National Law School's 5 years course of study in law and emphasis of instruction in upcoming branches of law, brilliant students generally interested in taking up law as a career are coming out. At the same time, in view of the trends of globalization and liberalization, multinational business houses and well-established law firms are offering attractive packages to the students who then cease to be available for the judicial services. Better service conditions need to be offered to attract the best talent towards judicial service. We can neither stop nor try to stop the influx of cases in the courts. However, the outlets can be increased so as to prevent the overflow or clogging. Alternate dispute resolution systems have to be adopted and innovated upon. In every department, there should be one retired judge of High Court or Supreme Court for resolution of some problems, and every small cases that are pending should be solved by that judge only. The legal proceedings should be simple, it should not be lengthy. Thank you so much.
And to what extent? These are common answers. This is already answered. Everybody has answered. Mr. Sood, Mr. Nasim, and Mr. Jain. What is to be answered? We have already given this answer in our speech.
In every aspect, it can be used. Decentralization.
Yes. Decentralization is required. It is required. I have told you that in my speech also. Nobody has said.
The word by itself suggests what decentralization is. That has to be applied in terms of judicial level. That will facilitate the dispensation of justice.
Yes, and that's it.
The very word decentralization suggests what it is. No, I would say.
Have their question. You put the question on me. Somehow.
No, the next step is there already. Not that we are rushing.
One minute. What are the remedies? We have already been saying what are the remedies. The lady, Mr. Abbas, even I said, some judges have to be increased, some other infrastructure has to be done, and lawyers should be replaced. They all outside. But these points, it have not been delivered by theirs. Whichever I submitted.
Let everybody share your idea. Just see.
Only 3 points I have. Only 3 points, very small. Your Lordship. Senior counsel take care for the case which is prepared by juniors. Whether there is any default with regard to affix stamps and copies of the documents and copies of the papers. Second, the counsel shall have to look into the facts in view of the law that the case is tenable according to Limitation Act or not. It is, if the senior is busy and has a lot of work, he should prepare the synopsis of the case and put it with the case in his office when the case came for hearing. And if he is busy, his junior may help the counsel to argue and help the court to argue and presenting the synopsis. It is therefore necessary. Case would not be adjourned. Thank you.
That is in fact being followed all over. Supreme Court insists upon the starting counsel to start the matter.
I think every day in courts we have been saying to the junior members of the bar that when the senior is not available to argue, let the junior. But unfortunately for us, juniors say, I have not read the paper.
That should be the spirit in the junior that he is ready and he can fill the gap. And if such a junior will find the atmosphere much more congenial, bench will be much more receptive and helpful. My experience as a junior lawyer has been, judges were more kind to the junior lawyer than the senior.
No doubt about
They would
it.
encourage.
Following it. But unfortunately you are not getting that survey. Or not. You
Part lies with us. Both as seniors and junior members in the commission. Juniors don't have the courage, don't have the guts to prepare and say, no, I'll start. The moment my senior comes, kindly permit him to take. But that matter are very. Please go
You are
ahead.
practicing lawyer?
Your Lordship, I am from Indore High Court.
Huh?
Indore High Court, Madhya Pradesh.
Indore High Court.
MP.
So in your High Court, judges are not saying that the junior should argue?
It was my
It
suggestion to not to be adjourned.
No, is it a new suggestion or what?
Yes.
Everywhere in India, the judges, lawyers are following this step. No problem on that. Unfortunately, juniors are not so much equipped as they were in the younger days.
Steal an opportunity to start making submissions in absence of the senior. They will endear themselves to the senior. They will get recognition from the bench. It will give them the courage to settle down in life quickly. Please take it from me. I tell you, I have been chairman of the Bar Council twice. I have had various offices in the Bar Association. I have worked all these years, against all matters in the profession on the basis of my experience of the judges. For the junior members in the profession, largely you will share my experience which I have mentioned.
Here I want to say one thing. My experience in the younger days as a lawyer, a junior lawyer in the court. When I started practicing, most probably when it was 82 or 83, I was to appear in a special bench of 3 judges. Against me, the 3 or 4 very senior lawyers of Calcutta were appearing in that special bench. That barrister, Mr. Bhabra, he argued for 2 days. Then my turn came at about 3:30 or 3:40 when the senior, the chairman of the bench, Justice R.M. Datta, told me, Mr. Judge, what do you want to say to the answer of the day for the answer of Mr. Bhabra's argument? Tell us in short, because we'll have to rise to the argument. I argued and give the point to the court, say about 5 minutes I took. Believe me, 3 judges started laughing, saying what this young junior lawyer is saying. I was a little upset. Then in the evening when I went back to my residence, and particularly my chamber, I was going through some of the Supreme Court, this part, and I found a particular decision of the Supreme Court. That case was related to specific performance of the contract. I went through that particular part and I found what I argued in the afternoon before the court. That was the decision made by the Supreme Court. Next day, I brought that decision with me, and the senior member who was arguing against me, Mr. Bhavra, saw that Supreme Court part and said, Mr. Jagli, what you have brought? I said, this is CPM जुग है तो CPM का लाल किताब दिखा के आपको मार देंगे. Then the judges came. When the judges came, I found Justice Chittososh Mukherjee was also a member in that bench. He brought that decision also, that part, with him in his hand. After sitting, he was telling the other judge, see, this young man has brought that decision. Then Justice Chittososh Mukherjee said to Mr. Bhavra that this young man was saying something yesterday. We laughed to find the Supreme Court has approved his. This is how things go.
My Lord, may I pose a suggestion, Lord? I am Ultimash Ray. So that's very troublesome for the clients. It has to be translated into English, and then it's expensive for him. So my suggestion is that the judgments from the lower courts from here should flow, that it should be bilingual in their own language and also in English. That will save time and money of the client.
That infrastructure possibly is not available in district courts.
But English should be there.
Huh?
It should be there because it's very difficult for them.
If we say that we want something in English, these lawyers object to that.
And Tamil Nadu, the judgment comes in Tamil. And from Gujarat, the judgment comes in Gujarati. Yes. So it should be bilingual.
Very difficult, but we can't help.
My suggestion.
That you are known for various useful public interest litigations. Kindly try this point in the PI. I don't think I should, my Lord.
I just don't know whether a PI lawyer. Thank you very much. Thank you very much.
क्या है डॉक्टर पारिया क्या खाओ सर ये लेसन चाय चाय टाइम नहीं थोड़ा इधर पूरा आने दो फोटो
Dr. Ranjit Singh, please. A bouquet and a memento for Professor Shiv Kumar, please. Dr. Parikh. Mr. Shiv Chand Sharma. Now I would request Mr. Justice Dalbir Bhandari to.
law schools and continuous legal education. I can see so many students because this is one subject which directly concerns them. And I would like that after, from this side, our short speeches are over, the students to take active part in this session. We would like to know their point of view about the legal education and how they would like it to be improved, what are their suggestions, what are their comments. We have a very eminent list of speakers this evening. Punjab is with us, and I would request on behalf of all of you to Dr. Singh to deliver his first speech.
Honorable Mr. Justice Dalveer Bhandari, other co-speakers and resource persons on the dais, distinguished members from the legal profession, dear students, ladies and gentlemen. At the outset, I would like to extend my heartiest thanks to Mr. Parekh for giving this opportunity to me, and my joy knows no bounds because I am speaking in presence of Honorable Mr. Justice Dalveer Bhandari. I have been his great fan from a very long time, but due to one reason or another, I did not get an adequate and a suitable opportunity to meet him one-to-one, and this opportunity came today. And I feel proud of myself because I am speaking from the same dais which is being adorned by none other than Mr. Justice Dalveer Bhandari. The topic is on legal education. I would like to make one statement at the outset. Whatever I am going to state, that is my personal opinion. It is quite possible many of you on the dais, off the dais, may not agree. But yet, to me, this is the truth. At the same time, I might have to be little autobiographical, for which I beg to be excused at the outset. In my personal opinion, legal education in India can be broadly divided into 4 phases. First phase is 1950 to 1970s. Second is 1970 to 1990. If we look back, probably these 2 phases are nothing but a mere history now. But yes, there is one exception to that history. That exception relates to the establishment of National Law School of India, University, Bangalore in 1987. And that exception is a very big exception, because for me, National Law School of India, ever since its establishment and working, has definitely made a big difference to the legal education in the country.